Welcome back, everyone. Today, Cassandra and I are discussing covering your own music. We had a discussion previously about making cover songs, so you might want to check that video out too. In this video, we talk more specifically about covering songs that you already own the rights to. The information provided in this video is for informational purposes only, and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular issue or problem. Hello, Cassandra.
Hi, Janae.
We're back at it again, and I feel like we did just talk, but it was like 3 or 4 months ago.
Yeah, I know. Time flies.
It does. But as we said, we're going to try to do these a little more often, and I think shorter sessions, so that will be easier for everybody to digest. So today, I wanted to talk about covering music again. So we have covered this in the past, but I specifically would like to talk about someone covering their own music. So they want to remix it, remaster it, but they're not really changing the words. And maybe we can talk about both, actually. Changing the words versus not changing any of the words, but it's maybe a remix, so the music might sound different. You understand what I'm asking.
Yeah.
So, can you take us through what a person would have to do to cover their own song from copyright right on through release?
Sure. Yeah, and this has been a popular topic. It comes up a lot in discussions with clients the past few years because this is essentially what Taylor Swift famously did. She re-recorded her prior albums and then re-released them herself. So kind of to go back, and I believe Janae and I did a prior video on the topic of the different copyrights, but just as kind of a refresher for everyone, there are two separate copyrights. So when you record a song, there's one copyright in the actual sound recording, which is what people refer to as the master. And then there's totally separate from that, there's a copyright in the underlying music and lyrics, which is the composition. That's the copyright people are talking about when you hear people talking about publishing. So you have copyright in the recording and then separate copyright in the composition. So the recording copyright, if you are signed to a record company, typically they will own the recording copyright, but you keep the ownership in the music and lyrics that you've written, normally, unless it's some type of a deal where the company is also your publisher, but we'll assume that's not the case. And so most of the time, if you're signing a recording agreement with a record label, there's going to be what is called a re-recording restriction in there. And what that is a clause that prohibits the artist from re-recording the same song that they've released through the label for a certain number of years. It can vary. Usually it's around 7 years. And the reason for that is the label doesn't want, once you're no longer signed to them, they don't want you to go and re-record the same song and re-release it, and now it's competing with their version. So they add in these recording restrictions into the contracts. Without a re-recording restriction, so setting aside for a moment the issue of the recording agreement, anyone can create a cover song of anyone else's song after it's already been released, as long as you don't change the music or the lyrics. So you, Janae, can go record a Beatles song as long as you get a mechanical license, which by law has to be issued, and pay the mechanical royalties. So that's why these labels add in the re-recording restriction to prevent artists from doing that, because otherwise they can go and release cover versions of their own songs, or if it's someone else wrote the song, doesn't really matter. It's the same process. So check your recording agreement, see how long that re-recording restriction lasts. If you're an independent artist, then obviously there's no re-recording restriction. You're not signed to a record company. So in theory, you can re-record your own songs whenever you want to and re-release them. If you make changes, so, Janae mentioned at the beginning, what if you want to make changes to it? If you're the sole writer and the sole copyright owner, You're free to make changes however you want. You don't need permission from anyone because it's your song, you wrote it. If there are other writers, then you have to get their permission before you can make changes. So when I mentioned that anyone can create a cover version of a song, you can't make changes. If you start making changes to a song that someone else wrote, you've got to then go and get a license from the writers and the publishers to create what is called a derivative work. So that's where you've made changes to someone else's work, and that requires permission. So if you want to release a cover version of a work that someone else wrote and you're not making any changes to the music or lyrics, you just get what is called a compulsory license. And it's very easy to do. If you want to make changes, you have to contact the publisher, contact the writers, get permission to do that. Also, if you want to put it in video, now it's a separate license. So the mechanical license, the compulsory license for a cover song, that only covers audio with no changes to the original music and lyrics. If you want to make changes and or you want to include video, now you've got to get a sync license to put it to video. So it gets a little more complicated if there are other writers and if you want to make changes or if you want to add a video. But if it's your song, you're the only writer, you're pretty much free to re-record it, make changes, add video, do whatever you want to do with it.
So there's a couple of things in there that I have questions about.
Sure.
So you mentioned getting a mechanical license, but that is only if you're covering someone else's song. Is that correct?
Technically, yes. And it gets even a little more complicated. Well, more complicated in one sense, but easier in another, because with streaming, the streaming services get those licenses for you. So you don't have to worry about the mechanical license or paying the mechanical royalties for streaming because that obligation is on the streaming services, Spotify, Apple. If you want to print vinyl or CDs, now it's your obligation to obtain the license. Or if you want to do downloads where people pay and then they download an MP3 and they own it, it's your obligation. But for streaming only, the streaming services take care of the mechanical license for you. So if it's your own song and you're releasing it on streaming, you're still going to get paid those mechanical royalties, even though it's your own recording of your own song.
Is there anything special you have to do when you are registering your own cover of your own song?
Yes. So assuming that you already registered the original recording and the original song, because again, they're two separate copyrights. So assuming you already registered those, then when you re-record it, if you didn't make any changes to the music and lyrics, you would only need to re-register the new recording. There's nothing special you need to do. If you make changes to the music and lyrics, then you would register the new recording. You know, if the changes are substantial enough, then you would also register the new version, which would be registered as a derivative work of the original composition.
All right, so you are still saying it's a derivative, even though it is your own song.
Yes,
Okay,
yes. If you made changes, if you made no changes,
right.
then no.
If you don't mind, could we look at a very specific example? And the one
Sure.
that comes to my mind, of course, is Dolly Parton and Whitney Houston. I
Mm-hmm.
Will Always Love You. Was the Whitney Houston cover of Dolly's song considered such a difference, do you think, that she had to or they had to register the song, and did it count as a derivative?
That's a very interesting question. You know what I'm going to do actually right now is I'm going to look on Spotify for the Whitney version and see who are credited as the writers. So this is a trick that you guys listening can use. One of the things I love to do is check the credits on Spotify and see who the writers are, who the producer is. So according to Spotify, the only writer on the Whitney Houston version is Dolly Parton,
Okay.
which means that it's not a derivative work, that it would just be a cover version and all of the mechanical royalties would go to Dolly Parton.
Alright, so they just had to get the license to cover. Interesting, because it is so different to me. I love both. I
Yeah.
loved Dolly's version when she first came out with it, and then Whitney did it, and I was like, I love them
Yeah.
both, but
Yeah.
they're so different. So I'm kind of shocked by that. But yeah, I think I wanted sort of an example so that people would be able to
Yeah.
gauge, I guess, what's considered derivative and what's considered just a cover.
Yeah, and it's interesting. It's pretty rare, especially for such a hit song, that there's only one writer. I mean, normally when you start looking at these credits for hit songs like that, you'll see many writers. So the fact that Dolly Parton wrote the entire music and lyrics is
Yeah.
pretty amazing.
But, that
Yeah.
was back in the day when most people
Yeah.
didn't collaborate the way they
Yeah.
collaborate. Today, good lord, there's 20 people on one song.
Yeah. And it's a gray area because I have, people ask me a lot. They say, I want to change one sentence or I want to change, one part or this and that. Do I need to get a separate license or can I just do it as a cover? And unfortunately, there's no sort of hard line about it. So, I will say publishers in general tend to be a little bit more easygoing than record companies. So, if something is probably a cover with not many changes, they may let it slide with just a mechanical license. Whereas if you were to use any of the original recording, for example, like creating a remix of someone else's recording or using a sample, record companies tend to be a little bit more strict. So, but yeah, there is unfortunately no, I mean, technically, if you start making any changes, they could argue it's not a cover, it's a derivative work. And so it can get a little bit blurry sometimes.
Okay. Now, my experience with the Copyright Office so far has been really helpful in trying to determine what it was I was trying to do with the registration and then guided me along path. I don't know if that's still true today. I mean, I haven't registered anything in a few years because I'm so behind, but you do this stuff like every day. Are they still super helpful like that?
Yeah, I mean, copyright registration, they're a little bit less hands-on, whereas trademark registration, for example, they're going to pick through every single thing that you put on the application. Copyright, they tend to, unless something really stands out to them, so, for example, if you submit, so when you register the copyright, as Janae knows, you have to submit a copy of the song. And so sometimes if the title of the file that you submit doesn't match up with the title on the registration, they'll reach out. Or if you say something is a work for hire, they may have other questions about it. But in general, unless they really see something on there that stands out to them, they don't reach out a whole lot. But they are helpful if you have questions as you're in the process of registering something. They tend to be very helpful if you call them.
Okay.
So if you go to copyright.gov, you find the phone number, and they tend to be pretty helpful if you call them and ask questions.
All right. And I think that I'm thinking about the time when I did a song and I decided to release a stripped down version and an instrumental version all at the same
Mm-hmm.
time. And they were like, okay, what are we doing here? But then they
Yeah,
walked me through it and it turned out to be fine. So
yeah.
I feel like, unless you have another example of a song that has been covered and whether it was a derivative or not a derivative, I guess that answered that. It's not quite as hard as it sounds.
Yeah, yeah, especially if it's your own song and you're an independent artist, so you own the original recording. The only thing I guess you want to watch out for is sometimes if you're releasing different versions of the same song with the same title, the DSPs can get confused about that. So if they see the same artist with the same title and there's multiple releases, sometimes the technology gets a little confused. So that's why sometimes you'll see people with a slightly different title, or I think in the example of Taylor Swift, she called the albums Taylor's version so that they wouldn't conflict on the different platforms.
Okay.
But otherwise, yeah, it's pretty simple. Again, if you are signed to a record company or were signed to a record company, you want to check that re release restriction and see how many years you have to wait before you can re release the same song. But otherwise, yeah, it's pretty simple.
And actually, now that just brings up another question. So I have a few songs that I never released. and I'm thinking about making some changes.
Mhm.
So it would be the same. You would just go through the copyright process, and it may or may not be derivative, but let's pretend it's derivative. But then I'm releasing this version, whereas the other version probably will not be released.
Mm.
Is there anything special there, or is just like, nope, just go through the normal process?
So when I said that anyone can cover someone's song, so if Janae releases a song that she wrote, a month from now, I could create a cover version. I just have to credit Janae as the writer, and Janae will be getting the mechanical royalties. But that only applies after the writer has approved the first release. So if you have songs that you've written that you haven't released yet, no one can create a cover version without your permission, because that would be the first recording released of that song.
Good to
So
know.
if you were to have songs that you wrote and now you made changes and you release a recording of the changed version, someone could cover that, but they couldn't cover the original version until you release it or approve someone else to release it.
But there's no problem with, because I own it, the original, making a new version of it and releasing that and still not releasing the original version.
Right.
Okay.
Yep.
Can you think of anything else that people might be wondering about?
I guess just, one other thing. So Janae mentioned at the beginning remastering or remixing. So when you talk about remastering or remixing, now you're dealing with that other copyright, which is the sound recording. And when it comes to sound recordings, there is no compulsory license. So you can create your own recording of a song someone else wrote, but there's no automatic license that allows you to use someone else's recording. So you can't create a remix and just credit the original sound recording owner in the same way that you can create a cover version of a song that someone else wrote. So if you want to create a remix or remastered version, you need to get permission from the owner of the recording. If that's you, if you're an independent artist and you own the recording, you don't have to get permission because you own it, so you can give yourself permission. But if it's someone else's recording or it's owned by a record company, now you've got to get permission to use that recording to create your new version.
Okay. Now, when you say remix, you know how people used to sort of chop up, let's
Mm-hmm.
pretend it's a Michael Jackson song, and they would kind of
Mm-hmm.
chop it up and maybe combine two of his songs and, come up with something new. Is that considered, first of all, a remix?
Yes. Yes, it
Okay.
could a remix or, a derivative work, but either way, you would have to get permission. And it's something that's become popular again. If you go, on Spotify and search different playlists of remixes, it's something that's started to become really popular the past year or so. A lot of them I don't think are authorized,
Mm.
so it's always interesting to me how they are allowed to stay up and they don't get taken off of platforms. But technically, in order to do that, you've got to get a license.
Yeah, I mean, I personally, because I used to have a radio show and, play, but it was all, I had the license to play the music, but
Hmm.
there were so many times that I was like, "Oh my gosh, I have, like, these 5, 7 songs that I can see a pattern, and how cool would that be to put it all together as one
Yeah.
song?" Um, and someday maybe I will do that, but I would need to get permission from each and every one of those writers, right? If not publishers, because
And
it
record.
is, yeah, and the labels.
Yep.
Yeah, because
Yep.
it's literally just taking their work and, yes, remixing it versus I'm singing it.
Yep.
But, yeah, I've often thought about doing that, and I just think that would be such a cool project, even if it's just one song.
Yeah. Yeah. I always love those mashups and everything.
Yeah.
I forget, there was a DJ that was really popular with those. This was maybe 10 years or so ago. And I used to love the mashups that he would put out. Girl Talk. It's always so cool to find. I think also as a drummer, like to hear the different beats matching up from different
Yes,
songs, it's really cool. Yeah.
exactly. I knew you'd get it.
Yeah. Yeah.
I feel like that covered it. If people have questions, of course, they're always invited to drop their questions on the video, but also you can hire Cassandra and go straight to the source. And so, yeah, as always, Cassandra, tell us how we can get in touch with you.
Sure. Yeah, the easiest way is to go to my website, and from there you can find all of my contact info. And it's cspanglermusiclaw.com.
cspanglermusiclaw.com.
.com.
Pretty
Yep.
simple. Yeah, I think this was great. I'm thinking it's gonna help quite a few people. It sounds so simple, but it can be complicated, and you might think there's a major difference between covering somebody else's song and covering your own song, and technically there is.
Yep.
And as always too, we invite everybody, if you have a question, please drop it in there. We will try to cover it, as best we can. It's hard when the person's not here with us to ask follow-up questions, so we'll do our best like we did in the last video. But like I said, if you are in need of a music attorney, you got one right here, Cassandra Spangler.
Thanks, Janae. Yes, and please, we always are looking for new ideas for topics to cover too. So if you have questions about other things aside from this, feel free to add those in the comments as well. It's always interesting to see what people are interested in.
And speaking of that, trademarks, that's your other big thing. So
Yep.
it doesn't even have to really have to do with music, right?
Right. With trademarks, it's all the same process. So it doesn't matter if you're an artist or you have a clothing company or you have a bakery or whatever type of business it is.
Excellent. And maybe someday, maybe if we can get in touch with people that do have questions, then we can bring them on
Yes.
actually. And that
Yeah.
would be interesting.
Yeah. That would be really cool.
So, yeah. All right, I'm open to it. And sounds like your game, so
Definitely.
let's do it. We just need the participation of people that have questions.
Yep.
Okay.
Thanks for having me, Janae, as always.
Always my pleasure, and you are so helpful. So, thank you.